Good morning, everyone. I'm the kind of pre-act before the actual show starts, so to say. My name is Elka. I coordinate the DSA40 Data Access Collaboratory, and my task today, or the task that I have today that you can also see, I have a lot of other tasks today, but my openly visible task is to kind of give you an introduction into data access. So while probably more people join and while kind of everyone gets settled, I can just speak. I would appreciate if you would not speak while I speak, but I probably can't help it either because there will probably be a few more people joining while I do so. But yes, today I will talk about data access, and before I start, I'm putting on a graph from an image of a paper of Joe's, who's actually here today, which kind of basically shows how we got here. And the graph starts actually, while I was still in like primary school, I think, with the founding of Facebook and the kind of entire social media ecosystem as we know today. And then we kind of get into like this what is sometimes referred to as the golden age of API, even though you could really wonder if it's so golden if you don't ask people for consent when you access their data, which is also kind of where the kind of big scandal in 2016 came about with Cambridge Analytica, which kind of where platform data was basically used to allegedly influence voting behaviors of people, right? And then we kind of get into like more structured data access programs like Social Science 1, right? So like the platforms don't necessarily always provide like the kind of easy to use or like very accessible data solutions, but we kind of get a bit more awareness for data protection, right? 2016-17 is also the time where GDPR is passed, right? So like we get some kind of initial data protection legislation basically. And then what is called post-API, I would actually, post-API age or API copalypse, as Axel Bruns calls it. You could also just say this is the arrival of the large language models, because this is basically where data generated by humans becomes very, 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 very valuable, because this is basically what is used to train these large function approximators, right? Conditional distributions over text tokens. And this is basically when all the platforms start shutting down their data access programs, or at least kind of massively increasing the hurdles for data access. Reddit does so, X does so, and Meta shuts down CrowdTangle, probably for different reasons, but still, because suddenly it's very important to keep, or it's even more important, right? So we don't just have kind of user rights to think of now, but we also now have to think of, what about competition? And this tends to be the time when platforms actually start doing something. And then the DSA is passed in 2023. So actually, 2022 actually, 3rd of October 2022, the DSA is passed. And then it comes into force in February 2020 or in 2023, and then fully for data access in 2024 in February. And then this also includes the data access Article 40, which I will talk about. But first, I will kind of speak about this part of the data access or part of the DSA of which the data access article is a part of, right? So there's this specific part in the DSA, I think it's called additional obligations. I think section 5, chapter 3, correct me if I'm wrong. And this is basically a part of the DSA which puts on, so the DSA is an asymmetrical kind of regulation in that sense, and that it kind of puts burdens on all platforms or on all kind of content distribution kind of services. But like the bigger the platform gets and kind of the more services it provides, the kind of more obligations have to be followed, right? And then at the very top, there are what is called the very large online platforms and search engines. And these are services which have more than 45 million, when the DSA says recipients of the service, right? So it's important that this is not equal to users, even though it's mostly equated to users, but it's not equal to users, right? It's basically people who receive these data distribution or information distribution services. And this amounts to roughly 10% of the European citizenship, right? So this is basically the threshold at which the European Commission, who designates these services, says, now you have specific risk mitigation obligations. I will actually talk about the kind of specific concept of risks a bit later, but this is basically also, so data access is also one of the risk mitigation obligations that these platforms have. And you can also here see the platforms which are currently designated. And I put some in italics, and I put a asterisk at some of these platforms. So firstly, maybe the italics ones, the ones in italics. So I think I can't quite tell if I put AliExpress in italics, because there were investigations into AliExpress, but they have been concluded actually. And they also were concluded even with some quite nice kind of commitments AliExpress made for data access. I'm not going to touch on that here because this is still the 101, but if you want to talk about the AliExpress commitments, you can obviously just speak to me. Then obviously Pornhub, TikTok, basically all the porn platforms, all the meta platforms, Temu, StripChat, Xvideos, and X. These are all the platforms into which the European Commission has opened investigations, basically. So this is basically the European Commission actively going out and gathering evidence to the fact that they are non-compliant with the DSA. And the ones with the asterisks indicate the platforms where researcher data access is an explicit part of the investigations that the European Commission has opened. So the platforms with the asterisks are the ones where we might today hear some information about issues with data access. But again, I'm not going to talk about the issues. I'm just going to talk very abstractly about what data access is. Now the question, I mean, already hinted at, right? The European Commission is the one that does all this, all these investigations, right? And they even grant themselves in the DSA with, I think, Article 56, paragraph 2, the exclusive rights to supervise and enforce all the obligations that apply to very large online platforms, right? And this again does not just include data access, but it also includes data access. And the third kind of bullet point already says they intervene at DSC requests. Now the question is, what is a DSC? A DSC is a so-called digital service coordinator, and I put this icon in a flag because they are national authorities, and I think that nothing stands better for nations than a flag. And so these are basically the independent authorities which are supposed to enforce the DSA for all platforms which are below these 45 million recipients of the service. And they also play quite a central role in the kind of vetting of researchers for data access under Article 44 DSA. What Article 44 data access is, I will also get into in a second, but basically this is the second kind of part of the enforcement structure. And then they also coordinate with other national authorities, and they do that as part of the European Board for Digital Services, which is basically where all the DSCs meet. It's chaired by the European Commission, and this is basically a way to kind of, or basically another attempt to kind of get past European federalism or actually make European federalism work, right? Because this has been kind of a big issue with European kind of digital legislation or legislation generally, right? That we're kind of a federalist kind of conglomeration of states, and that it's sometimes quite hard to kind of implement these kinds of legislations kind of top down, right? And this is kind of a way to kind of try and harmonize the application of the DSA in the European Union. Yeah. So, do I get to yes, we finally get to Article 40. So what is data access in the DSA? Basically, there's two kinds of data access I already hinted at, right? There's this Article 4 data access, which actually just says, if you look at the kind of specific wording of the specific text, it just says data access, right? It like doesn't say non-public data access, it just says data access, right? But it basically means non-public data access. Why? Because there's another article, Article 12, another paragraph of Article 40, paragraph 12, which kind of specifies that this is the paragraph which applies to publicly available data or publicly accessible data, right? And then the kind of recitals also give examples for this, right? So kind of aggregated interaction data, impressions, engagement data, publicly accessible posts, these kinds of things, right? And then by extension, the data that you can access through Article 44 is basically everything that is not that, which is quite broad. And there's recently been a delegated act which kind of tried to specify this a bit. And it's basically, imagine like very personal user data, right? Like so personal user trajectories, right? What did someone see at a specific time, right? Highly sensitive, highly personal data. But also information regarding their content governance, for example, right? So like internal documentations of the platforms. This would also be a part of the kind of data that could be accessible through data access. Before I talk basically about why this kind of data needs to be accessible, I'm just going to quickly talk about who can access this data, right? Because this is also not just like these kind of two articles or paragraphs also are split with regards to basically who is eligible to kind of access this data. And this is specified in Article 40, paragraph 8, which basically says, okay, here's a bunch of obligations, and some of them have to be met by all kind of researchers who apply for data access, and some of them are exclusive for researchers who want to apply for Article 44 data access. So I'm first going to start with the ones which kind of apply to everyone, right? So you have to be independent from commercial interest. You have to disclose basically where your funding comes from. You have to, and this is important, demonstrate your capability to fulfill the request-specific data security and confidentiality requirements, and to that end, describe the appropriate technical organizational safeguards, which, if researchers would have taken the GDPR to heart, would not be so difficult, but I think it's still quite a kind of high hurdle to jump through at times. And then the data access and the time frames requested for data access need to be necessary and proportionate, right? Which again kind of pays a bit respect to the data protection part. And it's like we really try to kind of not access more data, or like the legislator tries to make researchers kind of explain that they're not accessing more data than they need to, right? But this kind of applies to everyone, which interestingly means, and I will quickly talk about the research purposes already now, but the research purposes basically say that you have to investigate systemic risk inside the European Union, right? So the only limitation that we have here is a limitation on the research question, which basically means, and I think this is also why we have a lot of international colleagues in the room here today, you can apply for data access under the DSA no matter where you're from, as long as your research question touches on systemic risks inside the European Union, which is important to know. And yeah, so this kind of basically applies to everyone. And then another thing which is interesting is that the affiliation to a research organization is only a relevant attribute for access to under Article 44, right? So only for non-public data access. What does that mean? It basically means that anyone who can show that they're free of free from independent from commercial interest could theoretically use this, right? Which might be difficult for some journalists, right? But especially, I think this is especially important for CSO organizations or other organizations which kind of do not necessarily kind of fit into these very close categories of what a research organization is, even though if you look at the definition of research organization in the DSA, it's also not super close, right? So like your main purpose basically needs to be research that is kind of contributes to the knowledge generation inside the European Union, but you still you don't necessarily need to be part of a state-funded research institution, for example. And then we have another kind of the Article 44, basically. I think that I should have actually changed the slide, because basically the Article 4, paragraph 8f does not say that it contributes to the detection, but it just says it like also furthers the purposes again. So pretty much like E. And then interestingly enough, also you need to make your data publicly accessible if you exit it, or not the data, but you need to make your results publicly accessible if you access data under Article 44. Yeah. Basically, E is like F. Like, I also don't understand exactly why there's like a different thing. Maybe there's lawyers in the room that can explain me why, but basically E just says that the data access must be used for the purposes kind of set out in the request, which is basically like entirely how data access works in the DSA, which is what I'm going to talk about now, the purpose limitation, which is another interesting thing, because as researchers we tend to be, we just research, right? Research is free, right? Science is free, but it's not under the DSA, because the DSA basically says that you get this data access only if you contribute to systemic risk research in Europe. What does this mean? Well, for Article 4012, it says that you need to kind of contribute to the detection, identification, understanding of systemic risks, which are specified in Article 34.1. And for Article 44 data access, you can also assess the adequacy, efficiency, and impacts of risk mitigation measures, right? And this is kind of where we kind of lead back to the idea of risk that I already started to talk about at the start. So this entire kind of bundle of measures in this chapter for very large online platforms is about risk mitigation, right? And now the question is basically what kind of risk? Well, so-called systemic risk. And there's still not a lot of research on the systemic risk in the DSA. There's a bunch of research on systemic risk generally, which tends to come from complexity science. But the DSA basically says, okay, there are these four kind of minimal examples, I would call them, right? So like, and this basically means that the platforms initially, these are the kind of categories of systemic risk that they have to kind of look out for in their risk assessments, right? Because Article 34.1 is actually also an article which doesn't have to do anything with the data access, but this article obliging the platforms to actually conduct risk management procedures on these risks, right? And I mean, they include the dissemination of illegal content, which already is funny because there is no such, there is obviously illegal content, but the definition differs from member state to member state. For example, here in Germany, you must not use kind of imagery of Nazi Germany, right? Which might be legal elsewhere in Europe. Another systemic risk is the negative effects on the actual, exercise of fundamental rights, and then the DSA names a few. Again, these are only examples, right? Theoretically, it means all the fundamental rights in the European Charter. Negative effects on civic discourse, electoral process, public security, and then the last category is also similar to like the category C, a category which kind of bundles a lot together, right? So we got gender-based violence, protection of public health and minors, negative consequences to the person's physical and mental well-being, right? So like you can see that like there are some risks like electoral processes, civic discourse, public security, quite abstract, right? Very kind of system level risks. And then we have risks which kind of already literally kind of touch on the person, on the individual level, right? So like this is very, very broad. Also, if you, for example, think of child sexual abuse material, right? This is also a risk, right, where you would say, okay, it's illegal content, it's gender-based violence, and it's protection of minors, right? So you can already see that these categories are not mutually exclusive. And then the question basically becomes, okay, where's the border of these categories, right? What is not a systemic risk? And I guess we will potentially discuss this today also. But so theoretically it's quite broad, but still you have to limit, like you have to clearly show that your research only contributes to the detection, identification, or understanding of something that you can classify as systemic risk, right? Or you look at the mitigation measures. And this is kind of the other article, Article 35, right? So whereas Article 34 obliges platforms to kind of do risk assessment. Article 35 obliges platforms to kind of take mitigation measures. And these are, I'm not going to go through them because they are quite a lot, and this is already kind of an abstraction over all the stuff that's in Article 35. So there's a lot inside. And again, it's not an exclusive list, right? But it's kind of a list that platforms need to take into account when they kind of start applying the law, right? Which they have already done this year and last year, right? And this is also why I think the mitigation measures are much more elaborate, right? Because the regulator probably didn't want to give platforms an easy way out in saying like, yeah, you didn't call it, you didn't name it in the law, so we didn't kind of, didn't consider it, right? So like I think this is basically the reason why there's so many more mitigation measures than there is categories of risk, right? But there's all kinds of things which again kind of go both on the kind of system level, right? In the sense of like how does the platform work as a kind of technical system? But then there's also kind of mitigation measures which touch more on the organizational level, right? On the question of, okay, how does the platform governance or like how is the platform in itself governed, right? So this is basically also quite a wide range of potential mitigation measures, right? And again, not exclusive. So if you can argue that your mitigation measures or that you're looking at mitigation measures which would fit, or which you can argue kind of address a systemic risk, right? You could theoretically also get non-public data access based on that. So we've covered the purpose limitation, and now we get to my favorite part, the authorization procedure. Germans do love authorization procedures. And basically, it kind of differs between Article 12 and 44, as you might have guessed, right? And I already hinted at that the DSCs play a kind of central role in the authorization procedure of the Article 44. But I'm going to quickly just jump into authorization procedure for public data access. This is a kind of graph. I hope you can somewhat read it. It's also back there on the poster that we made. I think we're going to talk about this in a second. But if you want to really look at it in detail, you can kind of find it. And this is like, there's no time access on it. But basically, you submit an application through the platform's own form, right, which is already interesting, right? So the platforms kind of implement their own way of checking if you are meeting the criteria that I talked about in Article 48, right? So like, they all do it differently. It's great fun looking at all the different forms to kind of see how different kind of 12 platforms can interpret the same law. It's eye-opening, I would say. So, but imagine that you kind of figured out for each platform that you want to apply to what data you want to ask for and like get all the answers, right? So you have your data access application here, and then you submit it through the platform's forms. And then because the regulator expects platforms to, or expects these kinds of requests to happen much more frequently, because it's, publicly available data, the legibility is much more broader, right? They say, okay, platforms, you check it, right? We're not going to get involved, right? You just check it, and like you're responsible for seeing if everything is kind of fine, right? So the platforms basically check for completeness of the form, and if the form, if they have all the information basically to assess if the researcher is eligible for data access, right? And then they make a decision. Is it complete, yes or no? If it's not complete, or if the platform judges that the application is not complete, because again here, opinions differ, sometimes you get a request for additional information, right? At which time you need to kind of, again, you kind of provide additional information, right? And then the completeness check starts again. You can already see that this is a bit of a difficult situation here, right? Because who knows how long this can go on, right? We have examples for X. Again, I'm not going to talk about the experiences because this is later in the program. But you can imagine that this is like a tricky part of the application process, right? Because it takes a lot of time, or it may take a lot of time. But then, if we assume that like everything is fine and you're not rejected at the end, right, after going through all this stuff, and then they're like, no, sorry, like we kept you in this loop for like 3 months, but no, we don't think that you're eligible. But assuming that there's a positive, like assuming that the decision on the request is not negative but is positive, you get data access. And then again, the question of what kind of data access you get also differs, right? So this is what if people talk today about access modalities, this is what they mean, right? Kind of the technical, legal, and organizational kind of conditions under which you get data access, right? Usually you get access to an API, right? So which basically already means, okay, you need to know how an API works. You need to be able to send post requests, send requests of, get requests basically to an API. There's also the meta content library, which has a bit of a low code, no code solution, but generally like you get API access. Or you get a PDF, which says, you may scrape now. you may write your own scraper now, which is also great fun, right? Because this basically is the kind of most hands-off access that you can think of, in the sense that like we don't build any infrastructure, right? We just say, okay, hey, we whitelist your IP and off you go, right? Which again outsources quite a bit of the actual effort in data access, right? In kind of trying to get the data, like making the data accessible, right, to the researcher. But so this is basically what I mean here, right? That you receive access and then you get access credentials to whichever access modality the platforms deem you to be worthy of. I think we also have people today talking about the problems that they have with the specific access modalities platforms deem them worthy of. But yeah, this is Article 40.12. I also have a graph of Article 40.12 of this, but it would not fit on the slide. Again, I also printed it out, and it just fits on an A0 poster, so it's quite an elaborate graph. I also caught quite a bit of flack for that when we drafted it, but I wanted to keep the graph, so you can finally find it probably in its own and ever printed version back there. But so I'm gonna have I simplified it a bit. How does 40.12 data access work now? Oh no, actually, yeah. And then, yeah, I mean, I said a bit about the platforms, but basically some of them even report about the number of people that apply to the data for data access, and about the number of people that they accept, right? And you can see that something is a bit wrong, right? Because the acceptance rate is below 50%, right? So either people send in a lot of shit applications, right? Which could be if like the forms are not good enough, or like if the forms kind of don't encourage applications which are well thought through, right? If the forms don't provide enough information for researchers, right? There's a lot of reasons why the application could be subpar. But basically, you can see that like the acceptance rates that are plotted are not where you would want them to be if we would say that the access framework works, right? This is not what a working access framework looks like, but again, we will talk about this later today. So we have some work cut out for us with regards to Article 40.12. But now, what does Article 40, I forgot to change the 4 to a 12. This is Article 44 now. This is the non-public data access. And this was, again, specified just this July, on 2nd of July, through a delegated act by the European Commission. So the European Commission, like a year ago, had asked researchers and platforms to kind of put in and describe how they would kind of want this data access to work. Then they published a draft. Was it November last year? I think in November last year. And then people kind of feedbacked on that draft. And then this is now based on the final version that was kind of published in July and will actually come into force mid or in the end of October next month. So we're actually kind of very close to this actually being real, so to say, and usable. And you can actually already access the data access portal through which you will kind of send in this access application already now. So you can really like check it out and be like, oh, okay, these are like the information that I have to provide. But just in case that you don't have the access portal in front of you, I will just quickly go through what the information is that you have to provide to the access portal. So, and it's basically Article 48, right? Like, of course, right? This is what it is. So you basically kind of describe your affiliation, your independence, right? Your commitment to making the results publicly accessible or available, describe information, but then you also need to describe the data, probably much more clearly than you would need in the Article 4012, because in the end, the data that you ask for in Article 4012 is API access, right? And APIs tend to be documented, right? So there's not a lot of kind of question, right? But with Article 44, you may ask for data that you don't know if the platform has it or not, right? Where you may make a guess, right? Like the Delegated Act did say that, or does say that the platforms do have to provide data catalogs where they have to kind of detail what data can be accessed and how, right? But yeah, I mean, maybe we can like do a show of hands. Who thinks that the platforms will kind of, when we start, disclose all the data that they have? So, like, this is why you need to detail basically the data that you want, right? Because the platforms might also not have access to it themselves, but they can, or not directly have access to it themselves, but might be able to give you access to this somehow, right? So you have to kind of very kind of in detail specify what you want, right? And this is again also important because here we're dealing with data that is, for one, as I said, potentially very sensitive, in the sense that like it touches on like personal data protection rights, but it's also sensitive with regards to like trade secrets, right? So like if you investigate an algorithm, for example, or like the content recommendation, right? This is arguably core to many social media platforms, the business model, right? And so like you really have to be very kind of clear about what data you want, and that you don't use more data than you actually need for your research question, right? So and this also kind of then feeds into the necessity and proportionality aspect, and this is about the part of the risk that I just talked about. And then interestingly, there's a summary, and this summary will be sent to the platform so that they have a rough idea of what you want from them. But importantly, this summary is separate from the access application, right? Because the application, if you submit it to the portal, it will be vetted by the DSCs, right? And I put two little arrows here, right? Differently colored arrows. One for the DSCM, the DSC of the member state, and one for the DSCE, the DSC of establishment. Does anyone know what the DSE of establishment is for most of the platforms? Island, exactly. And I'm not going to say the name. I think it's Komissun Namean, but I'm not sure if I pronounce it correctly. So we just say the Irish DSC. But so theoretically, you have and this is like the other arrow. So you have the chance of putting in the request directly to the DSC of establishment, right? Directly to the Irish DSC. If that's a smart idea or not, I cannot tell you. I think we have to find out. But you also have the chance of putting in the request to your DSC of member state first, right? And then they do a sort of pre-vetting, right? So they kind of, this way you can basically take the pressure off the Irish DSC a little bit, right? Because likely they will receive a lot of requests. And this way you can kind of, also because you might have better contacts to your local DSC, this way you can kind of get your application pre-vetted, right? And then kind of they will send it then to the Irish DSC, who will make the final application, and then they either who will make the final decision, right? And then they either say, no, sorry, we cannot formulate a reasoned request. They have to give you a reason though, or they do what is kind of shown here, and they formulate what is called a reasoned request. And this reasoned request kind of includes the summary that I just talked about, right? A description of how the data is supposed to be provided to the platforms, and the kind of start and end of the access provision. And this is interesting now because as soon as a reasoned request is formulated, you, as a researcher, you will get data, very likely. Because the platforms only have two options now. Either they amend the request, right, and they can do that based on two kind of justifications, which is, for one, they don't have the data, and two, the data is touching on their trade secrets, so it's kind of very risky for them to disclose it. But they can just say, yeah, like we don't want to give it to you, but they always must, if they do an amendment, they must provide an alternative solution, right? So like, again, they cannot go back behind data access being granted. The question is just access to what data and how, right? And so the DSC can then see if it accepts the amendment request or if it does not, right? And if they then are still not happy, and then if the platforms are still not happy then with the kind of amended reasoned request, they can ask for mediation, right? Which interestingly, again, the DSC does not have to take part in. And in kind of both when evaluating the amendment request and the mediation, the DSC, the Irish DSC in most cases, or the DSC of establishment, may also involve the researcher who applied for the data access, right? So like there's this ways. And then we get to data access, and there should be like a lock, like an unlocked lock here, but apparently hasn't been rendered. But there's only half of it, and then the question is, then like you get data access, right? But this is not the whole story, because then you do the research activity, and I hope this next icon at least is rendered. No, this is the closed lock now. So basically, there's it's not data access like an API where you just save it onto your hard drive and then it's more or less yours forever. But access is terminated at a specific time, and then like you should also destroy the data, or you should it will probably be done in ways in which you, after the access ends, you won't have access to the data anymore. So you really have to think about, how do I make the results of my research activity, how can I kind of still store them in ways in which I don't lose them when access is terminated, right? And then you get to the last step, and I hope this icon works also, but no, it doesn't, just the other thing. This is basically then the publication of the research results. This is Article 44, data access. And this is all I had to say about data access generally. Just as an overview, basically, this is again the different kinds of data access. So if people start talking about 44 and 4012 now, I hope you have a rough idea of what I mean by, or what we mean by that, and about access modalities and all these things. And again, if you have any more questions, I don't know how much time we have left. Yeah, a bit. But otherwise, I would just say, okay, we're done. If you have questions, just talk to me. I'll be around the entire day. Grab a coffee, because I think in half an hour around we'll start, or like an hour. I'm not quite sure when the next program point starts. Oh yeah, over there, half an hour. And in half an hour, we continue with the actual program. So I hope you're all warmed up now. You know all your data access lingo, and I hope you enjoy our DSA40 data access days. Thank you.